Introduction. In the constitutional framework of the United States, plenary authority refers to complete or full power vested in a government body or official to act on a particular matter without external limitation, unless restricted by the Constitution. While the U.S. system is based on checks and balances, certain areas of governance still grant plenary powers to specific branches or levels of government. Understanding plenary authority is vital to interpreting federalism, separation of powers, and constitutional law in the United States. Definition and origins. The term plenary originates from the Latin word plenus, meaning full or complete. In American legal discourse, plenary power signifies total legislative or executive control within a defined area. However, this authority is rarely absolute in practice because it operates within the bounds of the U.S. Constitution and judicial review. Historically, plenary authority has been invoked in several contexts: congressional power over commerce and immigration, state authority over internal affairs, and the president's powers in foreign relations and national defense. These interpretations have evolved through constitutional text, Supreme Court rulings, and political practice. Congressional plenary authority. The U.S. Congress is often described as having plenary authority in certain domains explicitly granted by the Constitution. Commerce power. Congress holds broad authority to regulate trade among states, with foreign nations, and with Native American tribes. Over time, the Supreme Court has interpreted this clause expansively, allowing Congress to legislate on matters that substantially affect interstate commerce. Immigration and naturalization. Congress's plenary power over immigration is one of the most established doctrines in U.S. constitutional law. The Supreme Court has affirmed that the power to exclude or deport non-citizens rests almost entirely with the legislative and executive branches, largely free from judicial interference. Indian affairs. The federal government possesses plenary authority in dealing with Native American tribes. Although this power is subject to constitutional limitations and treaty obligations, it gives Congress wide discretion over tribal lands, governance, and legal status. State plenary authority. Under the 10th Amendment, powers not delegated to the federal government nor prohibited to the states are reserved to the states or the people. This grants plenary authority to state governments over local matters, including public health, education, criminal law, and family relations. This concept forms the foundation of police powers, the ability of states to legislate for the welfare, safety, and morals of their citizens. For instance, during public health crises such as the COVID-19 pandemic, states exercised plenary authority to impose lockdowns, mandate vaccinations, and regulate businesses, provided these actions did not conflict with federal law or violate constitutional rights. Executive plenary authority. The President of the United States also wields forms of plenary authority, particularly in areas of national security and foreign policy. While constrained by Congress and the courts, the President retains broad discretion in conducting diplomacy, recognizing foreign governments, and acting as commander-in-chief. Some judicial opinions have recognized the President's inherent plenary power in external affairs, emphasizing that certain executive powers are plenary and exclusive. Judicial limits on plenary authority. Despite its seemingly absolute nature, plenary authority in the United States is not unlimited. The Supreme Court has repeatedly emphasized that all governmental powers are subject to constitutional boundaries. For example, even Congress's plenary power over immigration cannot justify racial discrimination or violations of due process. Similarly, state police powers cannot infringe upon federally protected civil rights. Judicial review ensures that the exercise of plenary authority remains consistent with constitutional principles. Criticisms and debates. Critics argue that the concept of plenary authority can be misused to justify overreach and undermine the system of checks and balances. For example, The plenary power doctrine in immigration law has faced criticism for allowing policies that violate human rights or due process protections. Likewise, excessive claims of executive plenary power have sparked debates about presidential overreach and the erosion of congressional oversight. Conclusion: plenary authority remains a cornerstone of American constitutional interpretation, reflecting the complex balance between autonomy and accountability in governance. While certain powers are deemed plenary within specific contexts, they are never truly absolute. The U.S. system ensures that every exercise of authority, no matter how complete, remains answerable to the Constitution, the courts, and ultimately the people.